Judge, I would start out, but I want to cite the case of Irvin versus Dowd. And the case is 366 US 717. And it's a case that I think is directly on point as it relates to a change of venue. This is a rural community, and the case of Irvin versus Dowd talks about the inherent prejudice when you have a very small rural community. And I think in the Irvin versus Dowd case, they were talking about something that's probably 5 or 6 times bigger than St. Anthony. But in that particular case, Judge, they talked about the prejudice that's inherent when there is such media saturation to such an extent that everybody knows about the case, everybody knows about what's going on in the case, and that the very nature of that excessive and unrelenting publicity causes an inherent prejudice for a defendant to get a fair trial. And I would ask the court to take a look at the Irvin versus Dowd, because the Supreme Court of the United States has set forth criteria. And it's very specific criteria. It's very specific criteria that addresses under what circumstances does a barrage of publications and information cause this inherent prejudice. I would also like the court to look at it's Riddell versus Louisiana, 373 US 723. Again, it talks about how excessive press coverage causes and deprives a defendant of a fair trial. Now, my concern is this, is obviously in the small rural community of St. Anthony, we have had a tremendous amount of attention brought to this. That attention includes a number of pictures, obviously, on East Idaho News. Those pictures include a decoration of the county courthouse. Now, those decorations of the county courthouse in Fremont County, they came down after I made my bond reduction for Mr. Daybell well over a year ago. And it was only after I made that argument did that come down. Then the pictures on East Idaho News talked about the sign that was on the very front when you drive into St. Anthony. There's a sign in the very front of the city that you drive into, and on that sign, and for many, many months, Judge, and you'll look at the publications that were submitted to the court, Justice for JJ and Tiley. Now, that is a constant reminder for anyone who drives into St. Anthony and sees the publicity that is being presented. Now, again, right after the Daybell bond reduction motion, strangely enough, excuse me, that sign came down. The signs and the advertising at the Madison County Courthouse, and there's pictures of that as well. The pictures in Madison County and the ribbons decorating Madison County also came down. My concern, Judge, is that there's been so much publicity, and you're talking about a rural community, and I think Irvin versus Dowd and Riddell versus Louisiana are pertinent and offer some insight in what the court should be looking at in terms of how you make a decision as to whether or not this publicity has reached that level. There's also a case, Judge, and it's United States versus Rewald, R-E-W-A-L-D, 889 Federal 2nd 836 from the Ninth Circuit. It's 1988. Again, that's something else that touches on the issue of what's appropriate in terms of a significant amount of attention. Judge, when I took on the obligation to represent Mr. Daybell in this particular matter, I had no idea that this was going to garner so much attention. I would suggest that, Judge, other than a case that occurred in Minneapolis, this case has drawn more media attention than any other case that I can think of in recent history. It has been incessant. The exhibits that have been admitted, 1 through 8 of my exhibits, they aren't just a couple of pictures, Judge. They are a significant number of videos. They are a significant number of stories. They are a significant number of posts. And it's overwhelming the amount of attention this case has brought. Now, I'm not going to say what Mr. Wood's argument is, that maybe I haven't shown enough prejudice. Well, I think that if the court reviews Irvin versus Dowd and looks at the cases I cited, you'll see how the United States Supreme Court addresses this issue of incessant, excessive publicity and how it interferes with someone's right to a fair trial. I would submit to the court that the amount of attention has been overwhelming. Now, on August 4th, we had a preliminary hearing. It was the second day of the preliminary hearing. And on August 4th, Court TV and I believe East Idaho News published a letter, and I have included it in the submissions, from President Nelson of the Salt Lake City, obviously the president of the LDS Church. And that letter came out on the second day of the Daybell hearing. Now, I've submitted to the court, and I'm not going to go into the details of what was said in that letter, and I will leave it to the court. But what took place afterwards, Judge, were a number of conflicting opinions about people who felt the timing of that letter on August 4th was inappropriate by President Nelson. Now, I have had a wonderful opportunity, if there's any saving grace in me doing this, is that I have jumped into the task of learning as much as I can about the LDS faith. I've tried to teach myself. I've read many of their books. Chad actually provided me one of their books, and I read that. And I did some research on President Nelson. He has done nothing but live an exemplary life. He has been a pillar, and he's been an amazing role model for not only people in the LDS faith, but for people of all faiths. This is a man who has been absolutely exemplary in his conduct. Now, I think that and I'm not going to speak for him, but I think that his motive at that time was to say, listen, let the judicial system play out. The problem is that I don't necessarily agree with maybe his lawyers and the way they drafted that letter, and maybe he needs to look at some other lawyers. But this is not on President Nelson, and I will never disparage him, because everything I've learned about him and read about him is that this is an amazing human being.
Your Honor, I'm going to object on relevance at this point and facts not in evidence.
Okay.
Well, I'll consider the submission of the latter, but I think we're outside of the scope of this hearing.
Okay.
This line.
So I think that what President Nelson was trying to do was he was trying to downplay all the attention for Mr. Daybell in this case, but that submission on the second day of the preliminary hearing brought a lot of attention, and it came directly from the LDS Church, the top of the LDS Church. And again, I don't think President Nelson intended what he did was going to cause that problem, and in fact, I'm almost certain of it. But it did bring a lot of attention. Then sometime later, there was a submission, and this was at the request, and Judge, I've included it as part of the exhibits, and it's in the exhibits. If the court wants the date of when those exhibits were submitted, I believe that was on Fox 13 of August 12th of 2020. That should be in the documents that I provided to you. And what that was a letter from Heather Daybell. And I've included the entire letter as well as the media article that was attached to that. And in that particular letter, Ms. Daybell talked specifics, and she said some very unpleasant things about Mr. Daybell. But the concern I had was this, is that in the letter, she talks immediately, one of the first sentences was, at the request of President Dowling of the Henry Fork Stake. And this was also advertised on Court TV. Court TV ran with this story and publicized the entire letter and talked in detail about what Ms. Daybell had said.
Your Honor, I don't want to interrupt Mr. Pryor, but if we are going to be going into these specifics, I'm going to ask that we do it in a breakout room. And he's entitled to argue. I'm just saying if we're going to argue those facts that we've tried to not broadcast, I think that should be done in a breakout.
Judge, and I'm not broadcasting anything. I'm speaking in general, and I'm trying to be as sensitive to everybody as I possibly can.
All right, Mr. Pryor, hold on. There's an objection. I need to make a ruling on that. I am going to sustain that objection in terms that I think it goes beyond the admonishment I've had in terms of the specifics of the exhibits. Those are in the record and will be considered by the court. And I think if you would just refer to those by reference, but without going into the detail in your argument, knowing that those will be considered by the court. So if you'd like to point out or highlight any specific exhibits and how you think those exhibits legally affect this issue, then make argument on that, Mr. Pryor, please.
And Judge, my concern is that's tying my hands in terms of arguing specific facts about these things. But I'll obviously accept the court's admonishment and I'll move forward. So in any event, I would ask the court to take a look at the documents and all of the exhibits that were submitted in regards to Ms. Daybell. I would like the court to take a look at the area that was impacted by Ms. Daybell's letter, and as well as read the article that talks about the scope and the the range of where her letter reached and the number of people that it reached. Then we move on, Judge, to the next issue. Now, the next issue is that throughout this proceeding, there have been a number of vigils. Those copies of those articles are included in the documentation that I submitted to the court. There was a vigil, I believe, in Rexburg. There was a vigil that was done in Idaho Falls. My recollection is the one in Idaho Falls brought in several hundred people. I believe there was a vigil in St. Anthony, and there was a vigil in Boise. And the vigil in Boise drew, I believe, 24 people. So it wasn't as well received as the ones over here in Eastern Idaho. But the fact is that there's been the community brought together, and they've had these religious vigils, or however you want to characterize that, in talking about and bringing attention to this case. That obviously brings citizens from all over Eastern Idaho and it draws attention to the case. The next issue, Judge, is we are in a situation, and I'm going to move forward, where we are then having pictures of various businesses in the community selling items of memorabilia. Various citizens in the community, such as a bakery, that in their bakery at a very well-known grocery store in Rexburg are selling cupcakes that have messages that are directly tied to this particular case. And I'm going off, Judge, I apologize, but I'm going off of my slides. My concern is this, is that a combination of the significant amount of media attention, a combination of how the community has brought themselves together to conduct vigils, a combination of letters that have been sent, particularly in the Henry's Fork stake, that have had an impact. And we have no way of knowing when an email is sent out, what's the scope of where that email went to. The combination of people selling memorabilia such as sweatshirts and cupcakes in businesses within Eastern Idaho that directly reference this particular case. A combination of two courthouses in Fremont and Madison County, in which both of those courthouses have put up ribbons around the courthouse that have been posted by East Idaho News. A combination of the number of signs all over the community. Now that's going to have an impact. So I don't see how that's not prejudicial. And when the court looks at Irvin versus Dowd, you will see how the Supreme Court has ruled in that regard. Now, obviously, we're disappointed in the court's ruling as it relates to David Bryant and the survey that was done. But the reality is the results of that survey are disturbing. And the reality is that there has been an incessant amount of attention drawn to this case. And the reality is that what we need to do is get this out of an area where there is such a rural community that has made up their mind, that have, for all practical purposes, Judge, have got on the bandwagon of vigils, merchandising, and a variety of other things. And we need to move it to a place where there's a larger population base. And unfortunately, like many states, there's one large population base, and that's in Boise. And the likelihood is that if we are going to move the case, Boise would be the most obvious place to try to find jurors who either have not made up their mind or have not had a significant amount of attention drawn to this. To suggest that a rural county in Eastern Idaho, we can get a fair jury when this thing has been incessantly on the news for almost every day is absolutely ludicrous. And to suggest we can go to Madison County, to suggest we can go to Bonneville County. And if the court decides to move venue and considers Bonneville County, at that point, I am going to ask the court to take another look at our survey and apply it as I don't think it's appropriate that anywhere in the 7th Judicial District, this thing should be heard. My preference and choice of preferences are simply this, Judge. I would ask the court to consider Boise. I would ask the court to then, if the court did not consider Boise, I would ask for Twin Falls. If Twin Falls is not appropriate to the court, I would ask the court as a third choice to go to Pocatello. At that point, I think that we are far enough away. My final concern is this. I have no doubt that Sheriff Lem Humphreys is a honorable man, and I think he's a good man. I have only had one conversation. I don't even know if Sheriff Humphreys would remember that. We ran across each other on one of the streets in downtown St. Anthony, but I think he made a big mistake, and we all make mistakes. And I think in this instance, Sheriff Humphrey was honorable enough to say, I made a mistake. I posted this on my personal Facebook account, and I advertised that out there with not really thinking through the impact that would have. But the difficulty is when you're the sheriff in a position of authority in a rural community, and you post those things and talk about justice for JJ and Tylee, it cannot help but to have an impact on this community and influence them some way. So in conclusion, Judge, I would ask the court to strongly consider moving this case entirely out of the 7th Judicial District. I think that based on the cases that I've presented, based on the 8 folders, which contain subfolders of many, many, many documents of a variety of forms, it just doesn't make sense to keep it here. And the difficulty is this, is if the court even considers keeping it in the 7th Judicial District, at that point, David Bryant and his survey should be considered by the court, because at that point, we have a survey with legitimate results that says, unfortunately, 82 to 80% have already made up their mind that Mr. Daybell is guilty. This is
I'm not going to object to any comments on the subject of the polls. It's not in evidence.
Okay, and Judge, that's all I have in conclusion. Thank you.
All right. And that last reference to the exhibit that was not admitted will not be considered by the court, so I won't consider that part of the argument as well.